In this video, we're going to talk about 401k funds and three very important developments and piece of information to be aware of with a 401k fund. The first will have to do with cryptocurrency and digital currency. The second has to do with dividing up a 401k in any type of family event like a divorce, a death in the family, child support, and that's done using a QDRO. And the third has to do with a new law and some legislation being put forward that may have big changes in how employers automatically enroll and how employees get benefits from a 401k without even having to make any effort. So the first has to do with cryptocurrency and digital currency. The Department of Labor, which oversees and administrates 401k funds, has given some guidance to employers, plan administrators, and people who are in large corporations that are placing 401k fund capital on behalf of employees. And the question has come up, well, can you put that money into digital currency and cryptocurrency? Well, employees are seeing large increases in the value of things like Bitcoin and other digital currency. Many times they want their retirement accounts to be invested in these types of assets. And while there was no blanket prohibition on putting money into cryptocurrencies, plan administrators and the investment institutions themselves were very hesitant to put investors' money into cryptocurrency. And while as an investor you might think that it's a biased opinion to try to keep money in the traditional financial system, there were some legitimate logistical reasons for the plans hesitating. The Employee Retirement Income Security Act, or ERISA, is one of the regulatory documents that guide plan administrators on where they can put investor money. And some of the requirements that are in ERISA give some caution to placing money into cryptocurrency. And if a plan administrator offers something with cryptocurrency, they may be liable for losses. For example, ERISA requires that an investment doesn't have excess volatility or speculation. Well, cryptocurrency, almost by definition, is volatile and has speculation. It's a very subjective term. So if, let's say, a plan administrator for a 401k places money at the request of an investor into cryptocurrency, and cryptocurrency goes down, the plan administrator might be held liable for placing funds into something that was speculative or volatile. The other part of a 401k investment is that it has to be an informed decision. You have to be able to do proper due diligence on the underlying investment. So if you're purchasing a listed stock, you have various reporting documents, 10K filings, for example. SEC requires public companies to make their financial information public record. Well, cryptocurrency doesn't really have any due diligence type documents that can be used for informed decisions. Look, if you as an investor want to put money into it, that's fine. The problem with a 401k is it's somewhat underwritten and backed up by the government as a tax advantaged investment. And the other part of it is it's designed for the public good, meaning that it's designed to help individuals be secure in retirement. And the government's counting on that, because if the society is not secure in retirement, the government may have to step in with public funds or public programs to help secure people in retirement financially. So they don't want investments to go south and have retirees not have money. So not having the ability to do informed decisions and due diligence might jeopardize that. The other part of a 401k, putting money into digital currency that could be problematic, is there's a requirement for certain record keeping and certain custodial documents to be maintained. Well, the digital and somewhat anonymous nature of cryptocurrency makes that record keeping questionable. Now, one might say that the blockchain itself is that record keeping, but because that is not yet established and evidenced in the modern definition of record keeping, some of the plan administrators are cautious about using that type of investment. And then there currently are not regulatory oversight of digital currency. Things like SEC and FINRA oversee a lot of the traditional investments, but because cryptocurrency are used for sometimes illegal purposes or money laundering, customers who have money in those platforms could be affected if law enforcement, let's say, cracks down on cryptocurrency, or if there's a large drop in the value because, what if it turns out that 40% of cryptocurrency is held by people trying to do money laundering and the government cracks down on it? Well, that value may disappear. So using cryptocurrency in a 401k is currently not officially prohibited, but because of the fact that it doesn't meet the guidelines of what is allowed in those plans, effectively it's very difficult to do that as a plan administrator. There may be some exceptions to that, but that's what the current state is. In the future, it may be possible to have some of the regulations around 401ks catch up with the digital currency reality. But any plan administrator at the moment is going to very carefully weigh the risk of doing that versus the advantage for their client. So let's move on to the next subject, which is dividing 401k assets in the case of some family event, usually a divorce, sometimes a death in the family, sometimes a child support or child maintenance event. And because that the nature of a 401k is that it's specifically non-transferable, meaning you're putting your money into that account and getting some tax benefits and getting some government support for that account. In exchange, you're agreeing that you're not going to transfer that account to somebody else because the tax benefits and the government benefits are your benefits. They want it to secure your personal retirement so that the government doesn't have to worry as much about your retirement. So they prohibit any transfers of those benefits to a third party. Well, what happens if a person has assets in a 401k and they're married and they get divorced? Well, technically, those assets may be considered community property or marital property. But how do you transfer it if it is not allowed under the requirements of a 401k? Now remember, we're not attorneys. We're not giving you legal advice. We're just telling you the basics of what the process is so you can discuss that with a qualified legal advisor if you're in that situation. But there has been a allowance for very specific exceptions to that prohibited transfer if you are involved with a qualifying event like a divorce. So there's a legal process that can be done through the court that's administrating that event, and it's called a Qualifying Domestic Relations Order, or QDRO. And it's something that the court can issue that will give direction to a 401k plan administrator to properly divide assets. And the decision on dividing the assets is done by the courts, not done by the 401k plan. They don't decide who gets what or what the percentages are. It's decided by the court or by a negotiated settlement of the parties. And the order, once it's issued by the court and signed by the judge, is presented to the plan administrator of the 401k. And that plan administrator will then distribute the funds from the 401k per the specific directions of the order. For example, it may say take 50% and give it to this person, or take a certain dollar amount and give it to this person, or distribute X amount per month to the child for the next 10 years. It can be very specific. Now, it's important to make sure that the order that's being given by the judge does not violate any of the rules of the 401k plan. The judge may not be aware of the rules of your particular plan, and if the order is void under the 401k that you have, the plan administrator cannot execute it. Most courts know what the basics are of a 401k when they're issuing a QDRO. The problem is there may be some specific unique language in your plan that the QDRO is in violation of. And here's why that's important. A QDRO has to be valid under the plan. If it's not, it does not have to be recognized by the plan administrator. As a basic requirement, it has to follow the U.S. tax code, the QDRO. It can't accelerate payout of money. It can't violate the plan terms. For example, if the plan doesn't allow payment until age 55, a QDRO can't change and speed up that requirement. So make sure that whoever is drafting the QDRO, normally your attorney or an attorney representing a party in the case, also reads through the underlying 401k plan to make sure that the order follows the rules of the plan. It's normally a good idea to also have the plan administrator contribute their review of the order before having it signed by the judge, because it's very difficult to go back and revise the order later. The QDRO will normally specify the information on the parties, the name and identifying information for both parties, the spouse, the children, and also the instructions of the administrator on how to distribute the money. First and foremost, it's important to review the plan's rules and procedures. And having that QDRO drafted by the attorney, or there are some companies that draft these. Once it's drafted, make sure that the parties look at the QDRO and approve it. We've seen many cases where the plan was drafted, signed by a judge, and then afterwards one or both of the parties realized that it was different than what they expected. That's why it's a good idea to get signatures from both parties on the document before the judge signs it. May be required in your jurisdiction. Once it's signed by the judge, make sure it gets submitted to the plan. There have been cases where a QDRO is signed by a judge and it never gets submitted to the plan because the parties believe that, well, once a judge signs it, that must be enough. It actually has to get submitted to the plan, and make sure that you get confirmation that the QDRO is approved and is implemented by the plan administrator. And this can take a while. This can take several months depending on the jurisdiction and the backlog of your case. And last, we're going to talk about some new developments at the legislative lawmaking level for a 401k in the employment market. Part of the reason that the U.S. government is looking to make changes and improvements to the 401k process is because a larger percentage of the population is getting to be retirement age. By the end of this current decade, almost a quarter of the population will be 65 or older, retirement age. And that's a big increase from even just 5 years ago. Most of the people who are adults that are not yet retired have some retirement savings, but a large percentage of them don't have enough to fully retire and be secure. So the government is stepping in to try to accelerate that. And part of what they're trying to do is make it easier for the private retirement industry to be connected with employees and with future retirees. The first step in making that transition easier is requiring that employees are automatically enrolled in the company's 401k. In most instances, it's a manual process or voluntary process where when an employee starts work at a new job, they're given a bunch of forms and they can sign up for a 401k if they want to. It's not automatic. And many employees, if they don't intend to put money in, then they just don't sign up, because some employees say, I don't want any more money taken out of my paycheck to go into the 401k, so I'm just not going to sign up. They don't even sign up at zero. So the government is proposing a new legislation, which is on track to be passed, that will make it automatic when a company hires a new employee. That employee will be automatically signed up for the company's 401k. And it may also require that they're automatically put on a 3% contribution, meaning that the employer will deduct 3% of the income and put it into a 401k. It's kind of like forced Social Security, additional deduction. Now, the employee can opt out, but it will be an automatic sign up when they join up. The government's hoping that most employees will just keep that deduction. In addition, if there is a company match to that deduction, most companies have a match up to 3% in most cases. Then the company's match will automatically also kick in. Now, if it seems like more people are signing up for the company and it's costing them more money, they may reduce that match a little bit, but the idea is to get people on track with the 401k, because a 401k plan, when it's enabled and when people sign up for it, works very well. It's a good retirement benefit to add on to other things like Social Security and stocks and other items that may exist. It's supposed to be kind of like a forced savings for retirement, with the government incentivizing it by making it a tax deduction, so you don't pay taxes on that investment. Now, as a contributor to a 401k or an employee, it's important to make sure that your decisions are done the right way, meaning that you want to at least put something in, because remember, most companies have a matching contribution. So if you put in 3%, 2%, 1%, whatever percentage of your salary, tax-free, your employer matches that amount. So even if it's a small amount like $50 a week, $20 a week, whatever it is, your employer is going to put the same amount in on top of that to match it. So it's almost like free money. Plus, you get the advantage of not paying taxes on it and the advantage of it growing over time, especially now with the age of inflation. Inflation is going to be a benefit to investments, because as values of assets and products and services goes up, the prices of those services go up, and the stock price, that where most people put their money, may also go up. It's usually in a inflationary environment, stock prices go up in most cases for most companies. Now, a couple other common suggestions. Again, we're not investment advisors, but these are the most common normal recommendations by investment advisors is to choose stocks or investments in your fund that are low fees. You don't want to be paying a lot of fees to commissions, to advisor fees. You want to pick ones that have low fees because those fees just eat away at your investment. The other thing is there's two schools of thought on this. To not put money into your company stock. Wherever you work, you don't want to put money into your company stock because you are already somewhat invested in your company by working there. So the rise and fall of your fortunes based on the company's success is already kind of built into your employment. If for some reason your company has financial problems, that may cost you your job, and if you have money in the stock, it may cost you money on a loss of that stock. So some investment advisors want you to put money into other securities than your own employer stock, just to make sure you have diversification. Although it's not a hard and fast rule, and having some money in your company might be good because you may know more about your industry and your company than others. So if you see that there's advantages in your company and you can do maybe additional due diligence, that might be an advantage for you. Of course, making sure you're not trading on inside information. So a 401k is everybody knows about it. It's a common investment platform. It's common knowledge. But there are two or three maybe unique or not widely known factors of them. First of all, that cryptocurrency technically isn't allowed, or technically is allowed, but may be practically hard to put into your portfolio. Number two is those assets have one very narrow exception to transferring or assigning to another person in a qualified event like a divorce or a death in the family. And the government is looking to enhance the participation of employees and taxpayers in 401k funds using this new legislation. And that may be something that's a sign of things to come. They may be looking at the private sector to enhance support or maybe even replace Social Security, which sometimes is looked at as insufficient for a full retirement financial security.